Hello, hello, everyone. Good evening. I'm so glad that you could all join us. First and foremost, I just want to say thank you so much for your patience. We were having some really serious technical glitches. This is the day and age that we're in, so we're very dependent on this virtual stuff to work, and it doesn't always. I'd like to introduce myself. My name is Erin Sutton, representing the United Core Alliance here in Sacramento, which is cannabis social equity for the Sacramento area. And I'd like to let you know that today we have a wonderful workshop prepared for you. A lot of this has to do with some recent movement that has happened in the cannabis industry out here in the Sacramento region. So we thought it was necessary for this topic. Social equity, the next phase, how to protect yourself from potentially predatory offers. We are going to have this presented by Finkel Law Office and the Law Office of Dale Schaefer, and it's going to be presented as well by Heather of Agora C. Shortly, I'll be passing the mic to her. Again, I just want to say thank you to everybody for being a part of this workshop to kind of educate yourself about the different pitfalls that are happening right now in the cannabis industry and how we can probably avoid some of those things. And we're going to get that information directly from people who are in this industry, who are doing this work, who have been vetted and trustworthy. And because that's a huge thing here, we want to make sure that we're giving you good information and it's coming from a very intentional space. Again, my name is Erin Sutton. At the end of this presentation, we will have question and answer. So if you could, during the presentation, write down any notes or any questions that you may have and reserve those for the end, we greatly appreciate it. Also, at this time, I would like to let you know that this presentation is being recorded. The purpose of that recording is so that we can retain this information for you in case there's anything that you might have missed or somebody could not make it this time. We want this information to be shared as much as possible. And with that, I would like to say thank you, Heather, so much for joining us and for presenting this wonderful workshop.
Thank you so much, Erin. That was a wonderful introduction and welcome for everybody. This is Social Equity, the next phase, how to protect yourself from potentially predatory offers. Again, as Erin had said, this came primarily from some changes that had happened in the Sacramento region with the Social Equity program and just wanting to offer some assistance to social equity applicants. And so thank you so much for joining us. Next slide.
1 moment. Just 1 moment, apologies.
Up one. Thank you.
There you go.
So this is being presented by the Finkel Law Firm, as well as the Law Office of Dale Schaefer, United Core Alliance, and then myself, I'm Heather Schaefer from Agora C Business Services, and I want to take a minute, just a few minutes, to introduce everybody. I'll start with myself. I'm a 20-year paralegal who has decided to spin off from working as a paralegal with the Law Office of Dale Schaefer to offer business services to the cannabis industry, primarily to operators who are looking to either start up or expand their businesses. I do everything from submitting applications to offering education to offering compliance audits, and I've got a number of wonderful packages, so I encourage you to check me out. So I will toss this over to Mr. Finkel.
Hi, everybody. Thanks for being here. Thanks for the lovely introductions, Erin and Heather. My name is Robert Finkel. I'm a sole practitioner. I run Finkel Law Office. I've been an attorney for nearly 12 years, which pales in comparison to Mr. Schaefer, who will be on in a second. But in the 12 years, my first 5 or 6 years were spent in litigation. I was a litigator. That's how I cut my teeth in the law. I did all kinds of civil litigation, employment law, construction, real estate, business transactions, just about everything. And about 5 or 6 years ago, so about halfway in the middle of that career, I had an opportunity to take on more cannabis clients. I always had a few in there during the medical time, but right before regulation, I had an opportunity to take on some larger clients and gave me the opportunity to be a solo practitioner. And since that time, I've been a cannabis business attorney. And that practice has included everything from corporate formation and governments to transactions to going back to almost all the litigation that I did, right? The employment issues, the real estate issues that come up, leases, partnerships, regulatory compliance, dealing with the local and the state jurisdictions throughout the state, all the different types of licenses. It's been my bread and butter for a long time. And I've seen a lot, especially in the equity space. I don't have a lot of experience in Sacramento in equity. I know that just went through, but I do have significant experience in San Francisco, Oakland, and I followed LA and understand the principles and the concepts that come up. So thanks for having me, and I'm happy to help present about that and also to answer questions at the end.
Mr. Schaefer.
Well, good evening, everybody. I'm the old guy here. I'm 35 years deep into the practice, and I was trained to be a trial lawyer defending physicians, businesses. I've also represented cops in my day, and I was not into doing anything other than smoking pot until my wife got cancer, 1997, and the focus of your life changes, which it did. She was a physician, and we wanted her to have the legal right to smoke weed, and the doctors jumped up and down and turned apoplectic and wouldn't do it, and the cops got called on us, and we decided to do it ourselves. And that's how I got into cannabis law. I was primarily an expert assisting criminal practitioners at that point, and we were giving recommendations out, and federal government saw fit to put us both in prison for 5 years. So yes, indeed, I'm a convicted federal pot felon, but I never lost my law license. So I've been out of prison since 2015, and I came back, strapped it on, and looked him in the eye and said, now, how do we do this? So my practice focuses on everything from building the business structure, breaking the dirt, overseeing the building of anything from a building itself to TIs inside of it. Heather works with me to make these businesses run well, get them permitted and licensed, and then we also help them operate well. So we are doing all of that, and I am currently working with a group out of Stockton with an equity winner down there. And so this is right in front of us right now that I'm operating on. Mr. Finkel and I also had a social equity problem in the Bay Area. I was the mediator for a dispute with a social equity applicant, and it was frightening to see what had happened to this person. So when there were 10 new dispensary or retail store permits opened up, it was like you just shake your head. These people need to be warned about what's coming at them and know what the purpose of the offers are, what you want to get out of this. And if you're going to form a alliance, a partnership, form some corporation or business entity with someone that brings money or what they claim managerial acumen, understand what you're getting. Okay, so that's the whole purpose of this. And that's me. I'm the old guy here. And part of the delay was because they let me touch a computer, just to be blunt. So I don't touch it. Yeah, at least I admit it.
For the people that in the audience that might not know who the United Core Alliance is, would you like to introduce yourself?
Yes, and this is also, we'll roll into the purpose slide of this situation or this presentation to kind of let you know what's going on. So United Core Alliance was formed in Sacramento after the Sacramento cannabis social equity program rolled out, and we felt that there was a need for us to kind of come together as social equity applicants and individuals that are just defined as social equity applicants, come together, share some information, be transparent about what we're experiencing so that we can go ahead and help each other and find the resources that are truly necessary for our group of individuals, which is one of the reasons that we're having this workshop right now. A lot of things are coming to light in different ways at different times. And one of the things that's very, very huge is that a lot of social equity applicants are being taken advantage of. And it isn't because of ignorance, it's just because there are people out there that are preying on what you now have, which is access, right? So having that access almost gives you kind of a golden ticket as these people will look at you. But we need to remember we're human. we can arm ourselves with the tools, the minimal amount of tools that we need to, so that we're not taking advantage of whatever that the case may be, whatever you decide to do in your endeavors with cannabis business. So we want to just arm you with this information. As Heather's pointed out in the slide, she says, arm you with information to protect yourself. That is why we're having this workshop. United Core Alliance is really, as we say, for the people, by the people. So this isn't information that we're just throwing at you because we think this is what you need. This is something that we've noticed a lot of people asking about, and we want to make sure that we get it to you. So that's kind of where we go. Brandon Bolton, actually, who is my brother, started the United Core Alliance with that in mind. And we're so blessed to have organizations such as Agora C with Heather and Finkel Law Office and the law offices of Dale Schaefer to help us further that. And with that, I'll go ahead and let it go back over to you, Heather.
I think Heather's
Muted, Bob.
Yeah.
Oh, she's related to me.
No, I was muted and I couldn't.
I think you were muted. Yeah, I apologize.
Yeah.
I didn't see that. You're
Even
right.
I figured that out.
That's okay. Next slide. So the next several slides are going to be tossed to our legal team. So Mr. Schaefer and Mr. Finkel, take it away.
Okay, I'll jump in, Bob, to start this. There are numerous ways that people will come to you with offers to help you. Okay, I just talked to an equity applicant yesterday, and the way I phrased it is, you just got an opportunity, but you now are an opportunity, and you need to understand that we're going to go over a lawsuit at the end of this, high times an equity applicant. But one of the key parts of that is it took $1.6 million to build out a retail store. Okay, so when you have this golden ticket and you look at the realities of what it costs to build one of these businesses out, it's very expensive. Okay, and so you have an opportunity to work with some people here, and how they're going to come at you are through some techniques we see out there. One of them is called the Management Services Agreement. You're going to have a permit that you can pursue, and one of the problems we have right now with a license that touches the plant is the IRS does not let you deduct under 280E anything but the cost of goods you sell. So one of the structures that we set up is to move a lot of the income and what might be potential tax deductions from a business that touches the plant to another business. And then the business that touches the plant is then managed offshore or remotely, or however you want to phrase this, and you have the best tax advantage under 280E. So one of the approaches is to do a management services agreement. Someone will run your business for a price, a contract price, and what else goes along with that is where the strings get attached to money. Okay, another item here is a memorandum of understanding.
Dale, let me jump in.
Okay, Bob, jump in, please.
Yeah, no, I just want to do it one at a time. So management services agreements were generated, even they have a deep history. They came from the medical market, where there was a misunderstanding of an application of a law that said that cannabis collectives and cooperatives couldn't be for profit. And so the typical business formation was a nonprofit mutual benefit corporation. I don't know if any of you folks have been in cannabis long enough to see that, but that's how it was back in the day. So in order for these companies to obtain a profit, what they would do is they would hire a management, they would create a management services agreement for a management company. It was actually them. It was not a company. And so the not-for-profit cannabis collective or cooperative could then pay that management services agreement all their money, basically have their books at zero, right? They had all this income. Let's say they had $1 million in, they had $1 million out. It went to the management company, which then was used as a vehicle to make profit. Now that model is kind of lingered and changed throughout time for other various reasons. Another reason might be what Dale said, as a tax shelter or a way to avoid a 280E exposure to liability. But in this instance, or in the instance of equity, let's just break it down to what it is. It's about control.
Yeah.
Okay. So the management services agreement in the equity context is deployed where you need to show a jurisdiction that the equity applicant or equity qualified candidate is the owner and in control of the corporate company. So your corporate documents, whether it's a stock corporation or an LLC, will display to the local authorities that in fact the equity candidate has the amount of control they need. But the management services agreement, which technically is supposed to be disclosed, and maybe sometimes it's not, actually then shifts that control because it's a binding agreement. All right. So the person that providing the capital or that's helping the equity applicant basically has this binding management services agreement, says the management services company, controls the cannabis business, and that's the end of it. And it's binding, so you can't really cancel it, terminate, or change it. And so in the reality of what's happening is that it's being controlled by somebody else. So if you want to control your own company as an equity applicant, you need to take a look at if you're being presented with a management services agreement.
Yeah. Well, and one of the problems that we have been seeing with the standard equity applicants ownership or control situation is they want you to own 51%, which in math gives you 50% plus one. You control the company. And I think Sacramento's at 10 years now. They have varying amounts of time you have to do this. But what we found is that can tie your hands a lot in being able to bring people in to work with you. It's a long period of time that you're in this position. And when you get locked into some of these agreements, it's very difficult to get out of them. And you end up not being able to control. You don't have interest in running it. You may be in a position.
The revenue is diverted to the management services company.
All that stuff. And in one sense, I work with my accountant then, and we try to set these up for the best tax advantage. But if you're going to have an agreement like this, you need to look for an equally controlling interest in the business that's got this management services company. Agreement, so that you're in the same position. You can say yes or no to the major decisions.
Or have a backdoor, right? Have a way to terminate it. If you have it.
Yeah.
Sorry, Joe. I didn't mean to.
No. That I worked with a group. I represent Weed for Warriors. We did this in Los Angeles, and we actually put carve-outs into our agreement that when we reached certain metrics of success, we got to buy back or we got released from some of our obligations, so we owned the whole thing. There are ways to be creative about this, but this is just one of the ways you can get locked into losing control of your business and the money that's rolling from it. Okay, so anything else on MSAs, Bob?
I think that covers it.
Okay, now a memorandum of understanding. A lot of these are floating around, called MOUs. This typically is a non-binding. We got together and maybe drank too much whiskey and let's put this kind of thing together. It gets put into is a memorandum of understanding of what we're going to try to do. It's not a contract typically. It spells out some of the major features you want to move towards to get a contract in place. But these cannot be enforced in court normally. And when I do them, I put a very bold statement. This is not a binding agreement. We're working towards one. But this is how you get terms advanced towards you of what a management company might do, or someone that wants to partner up with you. Are they going to loan you money? Are they going to take an equity position in your business? It spells out, or it should spell out, their intentions with respect to your ability to get a retail store under your equity permit status here. Now, Bob, you want to throw some things in there that you've experienced?
Yeah, let me put some stuff against the wall. So there's several different documents that are entitled very memorandum of understanding, term sheet, letter of intent. There's these categories of documents that are really what I would call agreements to agree. All right. And they've been deployed in the cannabis space a lot of times, I believe, with a good intention, because things need to move very quickly. as you guys have all experienced, if you've all been through an application process, and how nerve-wracking that is with the deadlines and getting all the parties in line and getting all the agreements shored up. So, you know, it's these are what's put, and sometimes you need capital immediately. You got to pay your rent this month, otherwise you lose your real estate, and then the whole thing goes down the drain because you've got no place to actually operate the license, right? So whatever the case may be, these are agreements that are designed to get parties down the road and keep the wheels on the car and keep the boat from sinking. That's kind of real, or they're an origination of a deal that needs to get fleshed out more. But in any case, that's the good usage of them. The bad usage of them is, I would say that a lot of them can have binding provisions. First of all, a typically binding provision across the board, and I think that I'd recommend that anybody have it anyway, is a confidentiality provision, which could be called binding, and that could be in any of the documents that we've mentioned. And it could survive the termination, or whether the agreement to agree actually comes to fruition, because confidentiality is important. It's your information. So you it's okay that I think sometimes you're bound in that way. But there's other binding things, like if somebody needs money in, right? If you need money in, they can take advantage of you by creating an ambiguous agreement that binds you to this high level without really getting to the nitty gritty. And they've given you the money, right? So now you're bound to an agreement to an agree with ambiguous terms that you don't know. And what'll happen in an insincere situation is they'll come back and they'll say, well, these terms really mean this. And when it fleshes out, it gets worse and worse and worse. And now you're already on the take for some money. And now you got to worry about, do I have to pay them back if we terminate this type of thing? Right. And the terms keep getting worse and worse. So I think the lesson in the equity context for these agreements to agree is, don't get yourself into business with somebody, get an agreement to agree that has some sort of binding effect on you when the details that are important to you are not fleshed out. And I know that there's an impetus or desire or a need to do that sometimes because of the situation everybody's in. You know, you're trying to make something happen. You're trying to bootstrap into a business. You're trying to get funding. But if you do get into agreements to agree in that type of situation, you're already on a disadvantaged foot, because they'll have lawyers and they'll have people that will put together agreements that at the end of the day are not really the true sense of the original agreement to agree, and end up worse for you.
Seen it all. Yeah. And we have letter of intent, another couple down. I think Bob rolled that into this. We use these tools to begin the process. And Bob and I like to think that we are always up front and we're not trying to pull the wool over people's eyes, but we've run into a lot of people who just don't think that way. They are sneaky, or they think that they're making some deal with you. And if you don't understand the lingo that they use and the way they put these together, then you might understand what they're doing. I would always recommend you have these reviewed by an attorney to make sure that you're not bound to anything. And as Bob cautioned, before you start taking money from people, which might be the consideration needed to have this be a binding contract, for sure, have someone review that deal for you. Okay. Anything else in letter of intent, Bob?
No, I think, I mean, both of those are like the agreement to agree. One's a little bit less serious than the other, but I mean, I think we hit the germane point of that equity.
Now, operating agreement is a term that was thrown around here, so we threw it on this page. If you set up a type of business called a limited liability company, the document that runs, or is what I call the constitution or the working rules of that LLC, is called an operating agreement. It spells out who's in charge, how decisions are made, how you solve disputes. There's a whole lot of things, how you have meetings, a lot of things go into it. That's a formal document we put together when we put those businesses together. But the term has been used rather loosely as an offer to operate your business for you, which might be just a version of a management services agreement that you want to be clear of what it is, because you should have someone that knows how to draft these and set up a business or a corporation help you with the operating agreement. That way you know what it is. You help put the terms in there. They're explained to you. If someone's presents you with something that's being presented as an operating agreement, then either it's part of an already existing company, in which case I don't know why they're showing that to you, or it might be an attempt to get you to sign on to something that might bind you to, say, maybe a services agreement. We wanted to put this out there so that you will understand a formal operating agreement is something way different than someone wanting to work with you to set some contract up to have your licensed facility work with some other group. Okay. Now, you want to throw anything in there, Bob, about your experience?
Yeah. So, okay. So if you're a sole proprietor, right, you operate the way you want. You make all the calls. You don't have any duties to any outside people. It's just like myself or like Dale is, I think. I mean, we're pretty much sole proprietors, so we don't have partners. The reason that these agreements, like an operating agreement, come into existence is that it's a joint concept between the fact that there's more than one people or person. There's a partnership now, right? And that partnership is organized in a certain way, whether it's a general partnership, which doesn't require any type of official filings, or it's a limited liability company, which uses something called an operating agreement. We'll talk about in a second, but or a corporation. The reason that these agreements become required, right? And you really would want a partnership agreement when you have a partnership, even if it's not a formal business, because you have two parties and now you need to create understanding between the parties. And now you have obligations and duties between the parties. So it's very important to understand the purposes agreement, because this is a place where folks who are not necessarily, they don't know all the rules of the game in the corporate world yet, right? Or they end up in a minority position within a company, like they have a minority stake, or maybe they have a majority position in the company, but they have a minority position with respect to control of the company, right? These documents control the relationships and are designed to ensure that all the folks that are in the partnership are treated fairly and accordingly to their interest. And so these are very important. These are your governing documents. They create fiduciary obligations often, which is an important thing that you should be able to leverage when you've got, let's say, a partner who's acting in their own best interest and not in the actual business's best interest. But you'll want these governing documents to be well written and to spell all that out. And there's a lot of boilerplate in them, but there's once you read through one or two of them, you'll get to see where the important stuff is, because it's all about the control of the company and the dividends or the distributions from the company. But in an LLC, that agreement is called an operating agreement. Now, that agreement usually contains everything that we just talked about in terms of dividends and control and meetings of the members or meetings of the managers, which are the people that are either shareholders or operate the LLC. That's all in one document. They're kind of the simplest formalized entity. But there's also corporations, right? There's stock corporations. It's not an S or a C corp. That's more of a tax designation. It's a stock corporation where you have to have some governing documents. And that's where you have something called like bylaws and a shareholder agreement. And between those two agreements, you kind of get the full effect of an operating agreement. But in any case, these are important documents to put a lot of consideration behind when you're working with somebody to put a partnership together. And please, for the love of God, before you go forward in a partnership like that, or a LLC or a corporation, get those documents either signed or entered into the corporate record, right? Don't start operating with documents that aren't signed. Gosh, I've seen it happen multitudes of times, and there'll be excuses for that. And its insidious purpose, find somebody trying to take advantage of you. They're going to say, "Oh yeah, no, it's okay. We're close enough. Let me put some money in." Well, now they put some money in. Now they got their hooks in you, and now you don't have a signed agreement. And they might say, "Oh, it's a different agreement," right? It just what it does is it puts you at a disadvantage to prove what the deal was supposed to be if you don't have signed documents. Because then it's like, oh, you got signed documents, you've got emails. They may be baited and switched in an email that they're going to introduce that defines the agreement different than what the draft unsigned agreement is. It turns into a mess. And a mess is a bad situation, especially for somebody who's not really equipped to fight against a high times.
Mm-hmm.
So, yeah.
Okay. Well, I think we've covered this. I hope it's given everybody watching at least a couple of the terms, because they'll come up down the road when we talk about the high times too. So can we get the next slide, Heather? Yeah. Okay, this is where it gets ugly because the intention of these equity programs was to capture people who had been harmed by the war on drugs. Okay, it's unconstitutional to declare a race as a preference, and it turns into all sorts of battles. So none of these equity programs have anything about race in them. But we all know the Black community was just disproportionately affected. So they tried to set them up to help communities of color, especially who were ravaged by the war on drugs, get in these positions. But as we found them rolling out, that's not always where the slots get filled. Okay, and there's a lot of fighting. LA's got just warfare going on down there amongst different groups. Sacramento, I don't know if they have enough time in this to have the war start yet, but I think the war drums are beating right now about social equity losing its ability to control these businesses if you get them set up. And locking you in the way that they have, it has proven to be disastrous if you're just waiting for this to start making money. Because if someone will give you a stipend while you're waiting, if it's not making any money, it's a dead drain to the people who put money into it. So you can get deeper and deeper into problems because it's taking so much time to get these businesses actually permitted, state licensed, and to get them built out and operating. So those are a couple of consequences that I have seen. And one of the biggest one that I've seen is that the programs are not devoting dollars to people. I mean, not that I'm not going to promote Bob and I, but to take a look at what you're trying to get into, what someone's offering you, what business you're getting into, to help explain to you and in fact educate you about what it takes to run a business in this regulated industry. There's a big hole in this there. So you can be taken advantage of very easily, because if you don't have counsel helping you or somebody that knows what this is advising you, the things we just went over, these MSAs, LOIs, operating agreements, the things that try to get a hook in you, you can end up having lost the game before you even really got to start playing the game. So Bob, I'll leave some more stories for you here.
Oh yeah. Okay, so let's just be frank. You have to ask yourself what you want from this program. When I say program, the equity program, whatever equity program you're applying to, you have to ask yourself, you have to really say, what do I want? If you want a ticket to make some money and sit on the sidelines and kind of, that's the extent of the play, fine, do that. I don't think the advice that we're giving you is for that, though. We're giving advice for people who want to succeed. They want to start a business, own a business, run a business, use that business to leverage a positive impact on the community. Those are the people that I'm talking to right now, because the people that just want the ticket, that's the unintended consequence. There are folks out there that have no intention of ever trying to run a business that have the qualifications of being impacted on a war on drugs, and they'll apply and they'll get a stipend or a check for a while, and then they'll be cut loose and that'll be the end of it. I think that's happened probably quite a bit in Oakland because their equity program wasn't particularly robust on the regulatory side when it started. And I'm not sure where it is now because it's been a while since I looked at it. If you're the person who wants to have a successful business, right, you don't want just to be able to get, a check for a while and then get kind of cast aside. Then the deck is stacked against you, but there are things you can do to be successful and make that happen. And that really comes down to being prepared to negotiate with businesses and to be active with your local jurisdiction, and to get training business basics that you need to compete. And I say that because at least with, like, when I start talking about business basics, I'm talking about coming up with budgeting, finding out how much your company's actually going to need, realizing that you're not going to be in the black for a very long time, giving yourself and the folks that are going to be on your team, a something in terms of revenue and income for you personally, so you can stay afloat, but not taking more than that, because you're trying to build a business. And when you're going to get something out of it, you're 2 years, 3 years, 5 years down the road, because that's what every business in the world has to contend with, and that's what you have to think about. The more prepared you can be in that regard, the more prepared you can be to actually get funding, both from the social equity programs in your local jurisdictions that give that funding and from investors. And you'll know what leverage you have because you know how much money you're going to ask for and what you're promising down the road. And so, what have I seen in these jurisdictions? I've seen people who wanted to start a business, but didn't know how to do it, didn't have the resources, or try to educate themselves on business basics. And they found themselves in agreements like we were talking about earlier, whether it's actually signed documents in a corporate setting or MSAs or agreements to agree or unsigned documents, whatever the case may be. What they had created was something that wasn't practical or reasonable or wasn't going to make it to success. And so that's how they ended, despite that they really wanted to do that. So, there's in some of these jurisdictions, I think Oakland, I live outside Oakland. I love the city of Oakland. I don't want to disparage Oakland, but the requirements that they put on those equity applicants early on and the 2-year kind of runway, it left it so the vast majority of those folks didn't actually get to market. In San Francisco, which is one of my favorite jurisdictions for equity, I think they're doing the best job in the state. What I've seen and where it runs afoul is that it's too hard for those folks to get the funding. Many of these equity businesses didn't get to funding. But think about it. That's because you've got to put together the foundational documents that we've talked about and be able to present them to both the city and to investors and get the funding either from investors or from the local jurisdiction. I guess at the end of the day, and I hope I didn't give too much of a lack of hope, at the end of the day, a little bit of self-education, Khan Academy, getting online, spending some hours educating yourself on what a business plan might look like, what a pitch deck might look like, a lot of elbow grease is going to give you the best chance of success to get around the jurisdictions that have or to at least combat the situation where you lose out to somebody who's trying to steal your business or a jurisdiction that doesn't have its act together and you can't get the funding for it. And I hope I didn't ramble and make too little sense on that. Mm-hmm. It's such a big topic.
Well, it is a big topic. And I represent investors, the people who write those checks, and I know what they're looking for. And they're not always looking to take advantage of people. They're looking to get a return on their investment.
Or somebody that when they invest that there's going to be a success because they actually care about remedying the injustices of war on drugs.
Well, and the ethos of the people you're working with is something that, is never a bad thing to try to figure out. If somebody has a totally different outlook on your situation, what you're trying to do, the consequence of the war on drugs, then the odds that they're going to be really helpful to you are diminished. Okay. And there are groups out there that will look at funding some of this stuff. But if you're going to have $1 million, let's say, $1 million doesn't come your way without a lot of conditions, strings, whatever. They want to know, can you run a business? So that's what Bob was talking about, we call them pro forma documents. You've got to demonstrate that this is an investment that's worth their money for them to put it in. And you can't do this with the crayons on toilet paper. These are difficult things to put together. Not that they're impossible, but the entire picture to put in front of an investor. And it's not a game show. You don't go on there and, somebody gives you money with your pitch or not. You've got to be prepared to explain. And if you don't know what's in those documents and why they put them in there, it just puts you in a position where someone will then begin to want more control for the money they're putting in. And from the investor standpoint, that's the focus they have. They want a return on investment. I tell them, if you want to just burn $1 million, I'll back my car up and open the trunk, throw it in there. Otherwise, you want to try to put together a structure that you understand from an investor standpoint. And I don't know that these programs really give the equity applicants that perspective of you're an opportunity for people, but what does that mean and how do you protect yourself? Because those are the unintended consequences. People are looking to make money off of you.
And there's a good middle road. So the one path is to hire attorneys, right? But hiring attorneys for business consulting, honestly, guys, it doesn't make a lot of sense. You're spending too much with attorneys for just straight business consulting. There are local jurisdictions that have business consulting services. I understand. I might be wrong on this, and somebody get from the audience, or I don't know. Maybe Aaron knows what's going on in Sacramento in terms of business support services. But take advantage of those. I know Oakland has a pretty healthy program. I know San Francisco has a healthy program, and in fact, they go further. And I think there's some attorneys on a panel. So there's a pro bono panel. So those are resources. But this is where I think somebody like services that Agora C and Heather offer that can be very helpful, because the hourly rate on something like that is significantly lower than attorneys. And they can help you look at business plans, look at basic corporate documents that you should have in place for yourself to start with. They can help you start understanding what your licensing and permitting requirements are going to be. The rub on that, right? Lawyers, we report to the state bar, and we have ethics that we have to adhere to. With the local jurisdictions and whatever equity business counseling they offer, those folks are probably coming from a very ideal and real perspective where they want to provide help, right? But consultants, I mean, gosh, there's a lot of consultants out there, right? And I've heard a lot of horror stories about consultants. And so you want to, if you do have the ability to go the middle route and spend some money, but not attorney money, Heather might be somebody to talk to, right? But just keep in mind when you're talking to a consultant, be very wary of large amounts up front or large flat fees. It's like, yeah, I charge $20,000 to do this total, right? Soup to nuts. What does that really mean? And then once they get that money, what do they do with it? So you probably want to have people who have tiered approaches to business services that clearly explain the scope of work that they're going to help you with. Lay out the responsibilities, because look, they can consult and they can help, but just like lawyers, we can only do so much. If you're really passionate and you want to bring a business to market, an equity brand to market, do your part and change the world. You're gonna have to put in a little bit of elbow grease too. But there are good consultants out there. I would argue that Heather's services are one of them, but you'll just want to do your homework.
Yep. Okay, next slide. Okay. Now we picked out
the homework.
Yeah. we picked out some things that you would like to see ideally, and some stuff that you want to run from. So Bob, we'll just do each one other one here. You want to do that? Or you want to just take
okay. So let's just be real. I'll start with the capital, because I've tried to be as real as possible, and this is a place where I can really demonstrate what the real is. Okay, you have got to do budgeting to start your business up. Now let's talk about that. You're going to have real estate. That real estate is going to come with carrying costs, rent, right? That real estate's going to have to be improved. We call them tenant improvements, TI, right? In order to do that TI, you're even going to have to do an outlay to get the idea of what it's going to be, because you're going to have an architect draw up the plans. And then you have to have contractors do that work. And that's a whole nightmare in itself, and it costs a lot of money. You're going to have your business structures in place, your documents put together, where you can hire an attorney and where you need to, that's going to be a part of your budget. You're going to have starting inventory. You're going to have insurance. You're going to have employees. You're going to have technology and technology services. You're going to have vendors. You have got to really sit down and brainstorm and get all those line items down on a piece of paper, and then start to figure out how much that's going to cost. And I'm here to tell you, it is never going to be cheap. If you think it's going to be $500,000, even to start up something as simple as a delivery service, I'm going to tell you, I don't agree. I mean, maybe, but you're probably going to have to be up from there. If you're going to talk about a storefront retail or a manufacturing facility or a cultivation, add a 0. Okay, maybe add 2. I don't know. Depends what jurisdiction you're in and where the real estate is in San Francisco versus Sacramento. But you need to know what that number is, So that's the number you're going to the investors with and the number you're going to the city with. And then you're going to have to be realistic about what trade-offs you will have to do for that number, because there's always trade-offs for that money.
Yep.
So you do not want to leave. You do not want to start and take funding on a project on the not column when it says startup capital might be covered, but, because you know what's going to happen? You're going to get that deep in it, and you're going to be that much more invested in it, both in time and money and other resources. You're going to be strung out. You're going to be tired. You're going to have worked your butt off on this. And then you're going to find out you need more money. You always need more money, right? And that is when you're vulnerable. And that's when that money that you might get loaned by your equity, your partner in the business, right? Those terms are not going to be good. It's going to be worse than the starting terms for sure, right? So that's a way to chip away at what you're trying to build and what you might try to own or control. That money's going to come with gnarly terms. Anyway, that's my diatribe.
Yeah. Well, and as I said, I do these on behalf of the investors. And what Bob was just explaining to you is what they're going to demand at a minimum to see if this investment is worth their while to get into, how risky it is. And it's a risk-benefit analysis. You want to make your side as close to reality as you can get and be able to explain it. And it's difficult to do that. So, that's someplace we're going to put some hard work into, and it's not a TV show. This is for real. Now, the next item here is that you may be eligible for grants or loans. And when businesses come together, if you're not coming with money, then you've got to come with something else. If you've got the golden ticket and you don't have money, then it puts you in a different position. And if there's any money that's available that you could use to defray some of the costs, educate yourself, maybe contribute them in as a capital call to advance your position in your capital accounts, depending on the business type, maybe buy more shares. There's things like that are trying to get you in with more skin in the game, if you will. These are not necessarily bad things. You just need to know what it is. And if you do contribute money, what does that mean for your standing with the business? Is it being taken as a loan? It's paid back differently than if you just have equity or if you have shares. These are important things to at least get some idea of what they're going to want from you. But it's not necessarily a bad thing to improve your position if you have money become available to you. Anything you want to add to that, Bob?
I think we're not at an hour yet, but because we started rather late, but we're already probably about 15 minutes out from maybe question and answer. And so I think perhaps, unless somebody thinks otherwise, just high level on this, look, if no monthly stipend for living expenses, it's impossible to be a startup and have the people donating all their time to startup and not having the ability to put roof over their head. But the flip side of that is that startups and the pay for startups is small because the reward is the equity company. So you have to be reasonable about what you need to live and work on and to be able to do the work and make sure that that's in the budget. Paid upper management position with the business. If you are a executive officer to the company, which in most cases you have to be, yes, you deserve some of that startup pay. I think that kind of ties into monthly stipend, but at the end of the day, remember, it's still startup pay. It's not the jackpot. The jackpot comes later. The startup pay is what keeps you going while you're making yourself into a successful business. Training. This is really interesting, Dale, and I have not seen this yet. Maybe that's something that's part of your investor's book, but I love it. The idea that somewhere in these agreements, you're going to get basic business training that you may not have. So you understand what's going on. I think I would love to see that as part of agreements. I just haven't seen it yet. True equity position with equity rights. What it really means is you're not trading away your rights from some other agreement, like a management services agreement, or there's not some proxies that you're made to sign that give your control over to somebody else. It should be plain vanilla. You're an officer and a director on a board, and that board votes, and you have this many votes on the board or this many positions on the board, or this many shareholders votes based on the amount of interest you hold in the company.
Mhm.
Options to expand, that would be a Cadillac of agreement. I could see why that's an ideal. I don't know that it happens every time, but if you're going to build an equity brand, which I think has a lot of power right now, especially given the current state of dialogue and the need to fix this and the acknowledgement of that running all the way up from the federal government down to the local government, right? And in some cities, actually like San Francisco, one of the contingencies that they give on their operators is you want to do adult use, you have to actually work with equity candidates and buy their products and stuff and give them shelf space. So that would be great to see the opportunity to open up other businesses or to expand the brand. I just don't see it often. I'd love to see it. And now that's interesting. An opportunity to buy back most of all, if not all of the equity investment. I guess that's a double-edged sword, right? So maybe it's a loan to the company that you could pay back and keep your equity. And if you don't pay it back, then they convert to equity, right? So you get this opportunity to pay it back with interest. I like it. Dale's probably got a perspective on how often that works. And I'll shut my yap now because I just want to get through the rest of these slides and let people ask a couple questions. I think that's really important.
Well, I just throw it in. That was something we put into the Weed for Warrior equity contracts down in LA.
Right.
We call them carvebacks, but we were in charge of writing the agreements. But it ultimately fell apart, so it didn't come anywhere. But we did learn some things that if you're in a good position, you can advance your position. Now, on the not side of this, if you don't have a clear understanding of how money is going to come in, then you don't have an understanding, and you're likely to get screwed here. Because if it's got some other contingencies you don't understand, then it's going to be problematic when the money gets dropped in there and control is taken from you. That's the wrong time to be understanding this. Now, getting some money to survive is critical in these cases so that you can keep your doors open. And most people are willing to throw money at you. That's what they think you want. Let's give you a recurring monthly income here. It'll shut you up. You won't be looking too close. But you got to make sure that it's enough for you to live and you're not taking any more out of this than you need, so you don't deplete your position with that group. Training, I believe, is key. I set up a couple of corporations and LLCs a few years back for some people. When I asked them who's going to run it, I got blank stares back. So Heather and I did training for the corporate officers so that they would know what they were doing, how to run a meeting, how to actually make decisions, keep track of that and not run the company in the ground. So that's something that just a pet peeve of mine. You need to try to get that or as much as you can. Now, the equity position that you get from the local jurisdiction, you have to have for that license. Be careful that it doesn't get bled away and you lose control and you lose income. That we tried to warn you about some of those problems with these management services agreements. If they just want you to clean the toilets, basically, then be very careful of that, because you have a very strong position. You have to be a 51% owner of that license holding business. Don't let that be depleted. Don't let them just give you nothing to do there, unless, of course, that's what you want. If you want to run this business, take the bull by the horns and take that position. Okay. Now, the option to buy back shares, that's a discussion that I consider necessary for every one of these. If they run from it, it may not be something you can get, but you don't want to have your position diminished or diluted with any of these agreements you get either. That's the problem with off-sourcing all the money and control to another company. I don't know if they're going to let you buy back shares, but in normal corporations, there are first rights of refusal to buy back. There are ways that you can buy other people's shares if they decide to sell them. So it's possible to put these into these agreements. Now, expanding into other places, this is something that didn't happen with the High Time suit. They have an equity person there, and they not only given no opportunity to expand, they had stuff done to them they weren't told about. And the next thing you know, they have basically no control over their business. So these are all on the don't, if you can help them, get stuck with this. But this is, there's always give backs that you have. This is negotiations. You want to get as much of this as you can. Now, I sent this case over to Bob to read today. When I read this case as it came through the High Times lawsuit that was filed late last year, as I read it, it sort of gave a diagram of how an equity person got diluted and how that dilution into another company was bought up by some big company, and they were left sort of out there twisting in the wind. Now, if you don't know the backstory of High Times, I wouldn't be promoting buying their stock right now. I don't want to disparage them or be claimed of defaming them, but they're operating a lot with pieces of paper that are not U.S. dollars. They're stocks in High Times Corporation, and I'm not sure how much that's really worth. These deals don't have a lot of cash in them. And the suit came about out of Oakland, where an equity applicant formed an LLC with a company. That company had a management services agreement with another company. This person had to have the majority ownership for the equity position. But when they off-sourced this to the management services agreement and to this other company, then they lost connection to the equity person. They were effectively being controlled. That LLC they set up in the operating agreement, it had managers that were not this person. So they were just a shareholder in it. They didn't have any control over it. It's like in a corporation, you're not on the board. You have nothing to say about the board. You're just a shareholder. And that 70% of the income from that business was taken off through this management services agreement to another company that the equity guy didn't have any interest in at all. Well, there were companies out there that were trying to connect the management services agreement to as many retail stores as they could. They were trying to get into the retail market and buying these things up. And when I say buying them up, they were buying up the management companies, the management services agreements, which carried along with them control of the licensed entity. And this guy, I think his name is Chase, he got a little miffed at what happened when High Times bought up all the companies that had these management services agreements and had these management companies. They bought them all up, which meant that they now effectively controlled his equity business in Oakland. And it was a retail store, and he just wasn't going to have any part of it. So they got into a fight about who controls this. And one of the big points that I want to bring home to you is that this company came to them, and this is the original equity applicant. The company that came in to get the management services agreement dropped $1.6 million for the TIs and the other various and the sundry things to build out a retail store in Oakland. So that's the kind of money you're looking at. And when this person signed with the LLC and gave up his control, I don't think he understood that all the money and the control of his company was off-sourced. If he understood it, he didn't seem to act like he understood it. Okay. And the other problem they're facing is that there's no bankruptcy protection available for an entity that touches the plant. It's still a federal crime. And so you can't go to bankruptcy, to try to unwind these things. So what happened is they asked to have a receiver appointed. And that's the substitute for bankruptcy, but it's very expensive. The court ordered the receiver take over the control of all the businesses involved, grab their accounts, grab the money, put a management team in place. And now we're going to see how this is actually going to play out. But the lessons to be learned from this are, we have an individual in Oakland who was an equity applicant. Someone came to him with an agreement. He signed up into an LLC where he was a member, but not a manager. And those things we talk about if you want to get another discussion about what an LLC is and how they're run. But he found himself losing control of that business that he was the majority owner in. The money was all taken away. And when it was bought out, I don't know that he understood or agreed that another company now controls him. And so this litigation is ongoing, and it's going to be ugly. And I'm not a big fan of how High Times did this, because I think it's basically monopoly money stock. but they own these things. They have contracts. They bought them up. These contracts are assignable. So if somebody comes in and buys that company, all the contracts they have that are assignable go with it. And that's the nutshell of the problem I see with high times and how you might be able to have your eyes open here. Bob, what do you get out of that case?
Well, I don't know any of the background, right? I mean, the underlying facts, and it seems like, Dale, you might be more acquainted with it. But I guess if I was to assume, and it sounds like it's safe to, but I don't know, it's safe to assume that this was a gross example, probably a disgusting example, of a large corporation taking advantage of equity, right? Equity applicants, equity qualified folks. If that's what it was, then it reads like a freaking a manual for every single thing that we talked about that a company could do to take advantage of an equity applicant. Look at it this way. Look at High Times allegations. Read what they're saying. Management services agreement, stock transfers agreements, right? Board seats, like who is supposed to control what. You read it, and I read it, and I got lost in it, right? Mm-hmm. And I'm somebody who has to look at this for a living. What about somebody who expects to look at this and put it in a drawer and then go operate their business, right? So it stinks to high hell of a situation where everything that could be used in the book was used. But I mean, then the lesson to the equity applicants is look, I came up with this rule a long time ago. If somebody tries to explain something to me and I can't understand it, right? Especially in a business setting, especially when they're jumping through this to this to this to this to this, excuse the language, is probably bullshit. Mm-hmm. It's probably designed to take advantage of you. Now, don't get me wrong, there's boilerplate provisions and contracts that were incorporated in the contract in like 1922, and the law has not changed since then in this specific regard. And the darn provision is something you'll never understand. Okay. Because I don't understand, and I've searched them sometimes. Right. But I'm talking about the meat and potatoes. I'm talking about the control of the company, the distributions of the company, the cap chart, and what other documents are around it that modify those foundational documents. And so it's only some provisions, but the more complicated it gets, the more I would be concerned that it's not a genuine attempt to help an equity business. And Dale, you probably have folks who inside your investor groups who want simple, straightforward agreements and transactions. Yeah,
they do. But not all of them want to run these things. So there is room to bring money in either as a loan, which gets paid back usually before a lot of other things in business get paid back, or if they want to get an equity, they're going to offer their money for something. And the more you can show that you control your business, you know what you're talking about, the less apt they are to take advantage of you. Because I don't want to say that you shouldn't trust anybody, but don't trust anybody. Don't trust anybody, especially in this game. Okay. All right. Now we're at the question thing. And if you go too long, you're going to have to buy me a drink next time you see me.
Hey, Dale, I'll take you up on that offer. I hope you like your IPAs. So what I want to do right now is I want to invite the participants who have been here taking in all of this information to post any questions they might have in the chat right now. If there's any of these things where you have, I know a lot of it might be over some individuals' heads. There's some Googling that you might have to do when you get home about some of the terms that were shared with you, but this is all educational. This is the part where somebody says MOU, Memorandum of Understanding, and if you need to get a better understanding of that, then go to Google, find out, or contact Bobby, or contact Dale, or contact Heather, or even the United Core Alliance, because what we tend to do is vet resources so that we're not in predatory environments. We're really utilizing resources out there that are looking out for our best interests. And so I'm going to wait for the chat area to kind of have some questions filling them up. But I did want to go ahead and pose a question based on some of the information that we were given today, if that's okay. One of the things that I guess I was a little bit more interested in is I have individuals in my life personally who feel that business is something that you create and then you just sell it. And then there's other individuals in my life who say, no, I want to build this business as a legacy for my family. And I feel like either one of those is fine going into the deal. I guess maybe just, is it really, how important is it to know the intention behind the person, the investor that you're going into to deal with? Because I feel like, okay, well, I'll give you $1 million gazillion. I don't want to have to do anything. I don't want to have to run it. But then there are the investors who are like, no, I'm going to give you all of this money, but then it's going to be mine. So I guess maybe if you guys can just talk about how important maybe digging out that intention from your investor is, and maybe a way to do that to get to the core of why are they partnering with me?
Well, the intention of any investor, like a passive style investor or big money investor, is always the exit, though. That's the thing. It's almost always the exit, right? And so I think the answer is, I mean, you have to soul search within yourself and decide what you want to do, whether you want a business that you exit from in 3 to 5 years, which is kind of the timeline that people talk about, or you want a legacy business for your family. If you want a legacy business for your family, I think that the open market in terms of capital to start up your business, you probably have to avoid that. You probably have to look to friends and family. But I don't know. I mean, maybe Dale's got a different experience.
There is no good answer other than be prepared with what you want yourself. And I can give you the example. Yesterday, I had a discussion with this equity applicant, and I asked him, what does he want to do? He wants money, and he wants to be able to sell at a time and benefit from that. And that's it. It's like sold American, dude. We can wrap that one up. He didn't want to be involved in running this. But if you know what you want and you can understand what your end game is, if you're going to run it for some period of time and then sell it, you want to be in a position so that the growth in the equity value of the business is going to benefit you and not somebody else. And for an investor, they want to take a risk with you and they want to get as much of the growth in the equity in that business as they can get if it's going to be sold. And one of the phases we're in right now is called M&A. It's called mergers and acquisitions. And that's what High Times did here. There's businesses out there that got off to a running start and then started to flounder, and they're not doing so well and they're vulnerable to be picked up. If you're a new startup, it is absolutely critical that you really understand how you're going to deal with this person coming at you with money. And if you don't feel equipped, then please ask UCA. Don't be afraid to call Heather because she can help answer some of these questions. Bob and I are going to stand ready if we can help you. But wrapping this thing up from the beginning, that's what I try to do, is create for people that three-dimensional understanding of where you fit in this and how you're going to benefit. And are your end benefit goals really designed into the structure you're entering into?
Thank you. That was very helpful, right?
Absolutely. And while we're continuing to answer questions, we wanted to move forward to our contact page so that everybody can take the information of how to contact any one of us. And if there's
you could do Pamela at Finkel Law Office, or you can do Robert at Finkel Law Office too, just so you know. Info sometimes is monitored. I apologize.
And does anybody have any further questions? I saw some questions about when the video is going to be available. And I think I'll toss that to Erin because she probably knows better.
Yeah, so if you want to, what I'm going to do is edit the video a little bit, probably throw in some factual stuff across the slide so that you guys have some additional info. It will be chopped and screwed and passed on to Agora C, Heather over there. She will be uploading that to her YouTube, and United Core Alliance is establishing their YouTube, and it will be uploaded there as well. I do have everybody's information that joined and participated in the workshop today, so I will be reaching out to you with your through the contact information provided here to as well give you that link. But like she said, if you will go ahead and just take note of the contact information there and those 2 YouTube channels that I just posted in the chat, Agora Seas and UCA, you'll be able to see this as well. But please, I want to encourage everybody, if there's something that you have further, you need further information on, or you need clarity, I would really, really, really encourage you to reach out to Dale and to Robert Finkel, well, Bobby, and let them know and contact them. You know what I mean? It's not so much that we're trying to just get them business, but this is good business. They're here to help you. They're here to make sure that you're not getting taken advantage of, that these predatory offers, you can say, no, I've got somebody that I can trust to look at these. So that is very huge. But again, the video will be available on Agora C and UCA's YouTube pages. Thank you, Heather.
I see a question from
Yes.
Ekin Turin. If I'm not, I butchered words or name, so apologize. I'm not saying this correctly.
Building off of Aaron's question, what is the process for a social equity applicant to sell a business if the ownership of the license is connected to the equity applicant?
So that's the issue. That's an issue. That's a very interesting issue, and it really underscores. It goes back to where equity has gone wrong, right? The slide earlier, where we've seen things go wrong. Look, we're trying to do something a little unnatural in the business world. In most cases, corporations, sole proprietorships, partnerships, even licensed businesses, the sale process is not restricted to some amount of time. And in fact, it's freely sellable at all times, right? I mean, in a certain regulated industry, you might have to deal with some stuff, but typically, it's this freedom of contract and this freedom to do whatever the heck you want with a business. So when you overlay that with a series of restrictions, such as the inability to transfer, right? You get some results from that don't make a lot of sense. I'll give you an example that I'm well acquainted with. San Francisco has a 10-year ban, right? Or a 10-year requirement for the business to be in an equity, in a majority stake, in control of the business, right? And a lot happens in 10 years. And some of you guys might want to exit in 3 to 5 years, right? Some of you guys might want that family business that you stay in for the rest of your lives and pass on to your kids. It's okay. These are just different value systems, but one of them is automatically taken off the table in San Francisco because a normal exit might be a 5-year plan. So what do you do with that? All right. I don't know how Sacramento works. I heard Dale say something about a 10-year plan there as well. But okay, there you go. Somebody help me out. Thank you. Yes, 10 years. So in San Francisco, they've been able to replace equity applicants. So it's possible that you could sell and transfer, but the problem is that the person coming in would have to be an equity applicant, which kind of defeats the purpose. So I don't. That is something that has got to be addressed at the local level across the state, because you can't, there's just some restrictions, no matter how well-intentioned they are to protect a group of people that are trying to be made whole from damage to war on drugs, creates an absurdity for them as well. And I don't know, I think that you have to talk to your supervisors, you have to talk to your city councils, and those 10-year restrictions, they just got to change. It doesn't make any sense. And I'll tell you, the most famous jurisdiction for regulatory framework that doesn't make sense. I love you, Sacramento, but 10, 15 years ago, you had this idea that you could restrict transfer of control of a corporation when it's very natural every year for the control of a corporation to change. The board of directors are elected every year because of bylaws, so forth and so on. So well-intentioned, but bad legislation, and there's got to be a way to fix it.
Well, the restriction on transfer of licenses is sometimes complicated, maybe more than sometimes complicated by local jurisdictions, because the state requires a multi-step process to be able to transfer your interest in a state license. But local jurisdictions like Sacramento, they tie your hands up for 10 years. You can't do it.
It doesn't make any sense.
And if it comes to a point where there's a bubble about to burst and all of a sudden this business and your value jumps up to millions of dollars, and you just want to, sit on the front porch and drink Mai Tais, you can't do it. And if you can't sell it, there's no guarantee that you're going to have that bubble not burst before that equity value is going to be something you can take as value to you and your family for legacy purposes. It isn't just that you want to build a business that you're going to run for your work life, pass it on to your kids, things like that. That you're going to continue to want to do. But businesses operate and entrepreneurs operate to build something they're going to sell. Okay. They're not going to want to keep running it. And whether you're that entrepreneur or the person that's going to come in and work with you as that entrepreneur, it really ties people's hands and it restricts the ability to solidify these businesses and own them yourself. You end up in these networks and these webs of people that control you, just like we've tried to talk about here. And if you do transfer it, then it's a shell game because you got to stay in that position to hold that permit unless they let you transfer it. And other people around you can buy and sell. They can make money. They can, basically buy and sell their controlling interest. That's at the high times problem. So there is no clean path. I'm doing some transfers of licenses right now, and there is no clean path to do that. You can't just sell it, wash your hands. My family owned liquor stores when I was growing up, and we went to sell them. We put the liquor license on an auction. Someone wrote us a check, and we were out of the business. Okay. You don't get to do that in this if you're an equity applicant.
Which is crazy, which is absolutely crazy. You should be able to do that to some extent with reasonable restrictions. So it doesn't mean equity candidate gets taken care of. It gets taken advantage of, right?
Yeah.
I mean, I often like track and trace. Like it's akin to trying to track every single shot of tequila dispensed in a bar. Like,
Yeah.
Okay.
Sorry, I went off topic there. Folks.
No.
I think that's very valuable what you both are mentioning, because what tends to be happening now is we've got these crazy things that are being put on social equity owners that were never a part of any of those other licensees deals to get licenses. And so it's actually been a little bit more cumbersome, a little bit more legwork for social equity individuals to even get these applications or get these licenses, because they're having to submit personal resumes, personal, just little things that none of these other licensees have had to do. So we really appreciate you guys bringing forth the fact that, hey, we need to start doing this at a policy level, which is one of the reasons why I think this is great for other individuals to be a part of, so that they know, hey, we got work to do, and we have some grassroots efforts. Everybody that was a participant today is very, very strong in trying to get this right, and we appreciate you guys for helping us figure this out. We really do. Heather, is there anything that you would like to add to that?
I was just actually wondering if the attorneys want to leave the audience with some, piece of advice or anything that you feel like you really like, the number one thing you want them to take home. So let's start with Mr. Finkel.
Wow. Drop a question deep like that and hit me with it first too.
She's so deep.
Yeah, she's a beast.
I think that she was giving advantage to her pops, who we had to get on this thing in the first place, huh? It's not going to be easy. It's very, very discouraging what I've seen, and I can only say I've seen it. I can't say I've stood in any of your shoes on this one. But you've got to persevere, and you got to be active, and you've got to learn, and you have got to work hard. You've got to work hard. You got to work harder than those corporations that you're trying to deal with. And if there's any illusion, and I don't think there is, I mean, there is a little bit every once in a while I see from the legacy market, because there's success selling weed. And let's be honest, it's not too hard to sell weed, okay, especially on the legacy market. Business like this is not easy. You are jumping from, in a lot of cases, a completely unregulated market where you weren't even required to pay taxes and weren't afraid of a judgment because your money was under your mattress, to industry that's regulated like depleted uranium. It's absurd. It's absurd even for folks that have the money and the resources and the knowledge in place already. So it's going to be doubly absurd for somebody who doesn't have one of those components. But persevere. I've seen equity in programs improve over the years. Again, I'll point to San Francisco. One of the things that they're having a hard time doing is getting the grant money out. I think they should get better at that, but I love them down there, and I hope that they're successful at that. And something that I just wanted to say from kind of Aaron's earlier point on how, equity applicants actually have to do more just to get through the application process. And this is something you should burn your biscuits a little bit, and you should definitely think about writing your representatives on. But the state gives out grant money to equity, right? And they've been giving out a lot of money to these jurisdictions. And that money has not been spent in a lot of cases. I challenge you to look at the other grant money that the state has to give out under Prop 64. And that is for education and health and safety. Bet you that money's spent. I bet you that money's spent because that's money that a city applies for and spends on its departments, whether it's its police department or its education department or wherever else. So why isn't the equity money needs to get spent?
Yeah.
That's all I had to say.
Mr. Schaefer.
Well, I would like to tell you, don't trust anybody. As my opening salvo here, but I help people trust but verify. And part of what we talked about here was to verify that what it is someone is trying to sell you isn't a bill of goods. They're not a carnival barker trying to get you to come in and fleece you. That's the starting point. But what's discouraging to me is that I see efforts being made to try and undo some of the damage that's been done, especially to communities of color. And you wonder sometimes if you could screw this up any worse. So, I'm passionate about bringing people of color, especially women of color, into the industry, and not just cleaning the bathrooms, running these businesses. So I want to do what I can to make sure that you're in the best position so you have an opportunity, but the opportunities are fair. And part of what I'm seeing is that they're just not that fair. And if you don't do the extra legwork, which has been what's been laid on communities of color since I was a kid, to go the extra mile to prove you're worthy, then you're going to get shit on. And it's just hard to watch. So you do need to have a connection with all the city council and the people inside that run these. And you've got to advocate for this to be looked at and scrutinized so that you actually have a way to advance your positions in real time and you're not taken advantage of. They should be helping you to be trained. I don't know what they're doing with that. But if you don't know how to run a business, then someone's going to take advantage of you. And if you don't really understand how to run in this regulated market, someone's going to take advantage of you because it's complicated. But I'll tell you, a ray of hope is if you can figure out how to do this in the most regulated and taxed state regulated bullshit market in the country, you can do this anywhere. Okay. So have some hope.
You're a winner. Yeah.
Amen to that. Thank you so much. And on that note, I would like to say thank you so much, Mr. Schaefer. Thank you so much, Mr. Finkel, for basically parting this information upon us because it's so important. It really, really is. And I also encourage, like I said, our guests and participants to contact them with additional questions that you may have gathered from this presentation. I'd also like to thank very much so Miss Heather Schaefer of Agora C for putting this little thing together. It's not really a little thing, but it's very impactful, and they are constantly trying to assist in the world of cannabis business. So please head on over to her site as well and see what they have to offer. Again, thank you all so very much. This is being recorded. That information will be on Mr. Dale Schaefer's website, which is given in the chat. Also, you can see the information provided on the slide. If you have any questions or you need any further resources, please always feel free to reach out to the United Core Alliance so we can help direct you in the best way possible. On that note, is there anything else that you two would like to contribute? Or are we good to go? We're having a good night?
Thank you so much for putting this on, and thank you to everybody for attending. Really appreciate you.
Yeah, thank
Yes,
you.
thank you. And on that note, you all have a wonderful evening and a wonderful rest of your year. Have a great one, everyone.
Peace.
Peace.